Please, Lordship. This case petitioner is my lord, presently, my lord, as an advocate, my lordship, after retirement from the service as headmaster of a elementary education school, lordship, he is joining the bar, lordship. Now, my lord, the petitioner, my lord, filed this petition, my lord, for quashing, my lord, DV petition, so far as my lord, petitioner is concerned, my lord. His, my lord, daughter-in-law, lordship, filed complaint petition under DB Act, lordship, against all the allegations, my lord, against the husband, lordship.
Where is
The
the DB
petitioner's son.
complaint?
The petition is at page 46, starts, lordship.
Page 46.
46 starts, my lord. 40, it's 47, lordship. The accused number 1 is his son, lordship, his husband of the complainant, and 2 is the petitioner, Abdul Khalik Ahmed, lordship. My lord, all along the allegation is against the, my lord, respondent number 1, husband, lordship. Now, as a formality, my lord, it is his name, petitioner's name is, my lord, incorporated, lordship. Some vague allegations are also there,
Where are the
lordship.
allegations against the petitioner
My
number
lord,
2? Petitioner here.
Petitioner number,
What are the allegations?
yes, lord. Petitioner number 2, lordship.
The petitioner number, only petitioner, right?
Lordship.
How many petitioners here?
One petitioner.
One.
Only, my lord, petitioner, my lord,
Okay.
father-in-law,
What are
lordship.
the allegations against the
My lord,
petitioner?
paragraph, my lord, 9, lordship.
Paragraph 9.
9. Paragraph 9 and 15, lordship. Respondent number 2, lordship.
And 15.
15, lordship. This is the specific allegation against the petition number, petitioner only, lordship.
Yes, Mr.
At paragraph 7, it is stated that she stayed, my lord, for 12 days at, my lord, in-laws house. Paragraph 7, lord. Page 50,
Page 50.
lordship. In fact, my lord, petition number 1, respondent number 1 and the complainant had
Which
affairs,
place,
lordship.
which place? Paragraph number?
7, lordship. Paragraph 7, last sentence, lordship. Paragraph 7, page 50, last sentence. Her conjugal life was not happy.
We agree with the... Yes, Mr. Kushik.
The party and I don't have the copy of the petition.
Oh, you are not a party?
We are not a party, man.
My lord, on the same, my lord, cause of action, lordship, FIR was also lodged, charge sheet was submitted. That charge sheet has been stayed by this honorable court, lordship. That order is, my lord, at page 34, lordship. Divorce petition has also been filed by the my lord, complainant, lordship. Page 34, kindly see.
Page 34. Trustee.
That was, my lord, against the husband, lordship.
What is this proceeding?
My lord, proceed. My lord, in that case, lordship.
What proceeding has been stayed?
My lord, proceeding in the, my lord, criminal case, lordship.
Where is that?
Page 30.
That is the order.
Order is lordship. That is order. That is not annexed, lordship, but
What is the
statement
case?
is there. Page,
Under what section?
my lord,
Paragraph
page 34.
Nexus 6. There is no description. No one should lodge a false and concocted affair. Huh? For what offense?
My lord, offense, my lord, that is affair is at page lordship, annexure 4 lordship.
Annex 4.
Yes, Lord.
Page.
Sorry, I'm sorry, lordship.
That is affidavit.
Lordship, that is affidavit, lordship.
Nothing is there.
It is nothing, it is not annexed, lordship.
Or all accused, everything, all affair is false
Only
and
one accused, my lord,
concocted.
against husband, lordship. That was against husband, lordship.
Huh?
Not the petitioner.
Correct,
lordship.
accused. Okay. Okay, that is against husband.
Lordship.
Yes, okay, heard Mr. M.H. Hamid, Land Council for the petitioner. Full stop. The criminal petition is preferred seeking quashing and setting aside of the proceedings of DV case number 146/2025, presently pending before the Court of Planet Chief Judicial Magistrate, Kamrup Metro, Guwahati. Oh, no. Presently pending before the Court of Planet Judicial Magistrate, first
Lord.
class, number 6, Kamrup Metro, Guwahati, insofar as the petitioner is concerned. Full stop. Para. The respondent number, the respondent as the aggrieved person has instituted an application under section 12 of the Protection of Women from Domestic Violence Act 2005 before the trial court. Seeking relief under section 18, sections 18, 19, 20, and 22 of the DV Act. First of, the said application was has been registered and numbered as DV case number 146/2025. First of, in the application, the respondent, apart from arraying her husband as respondent number 1, has impleaded the petitioner as the respondent number 2, who is the father-in-law of the respondent of the respondent. Full stop. Para. Mr. Hamid, Learned Counsel for the petition, has submitted that in the application under section 12 DV Act, the respondent has made certain vague allegations against the petitioner. First of, after solemnization of the marriage, the respondent and her husband had hardly stayed for a period of 12 days at the house of the petitioner in the year 2022.
Lordship.
Full stop. and the house of the petitioner cannot be termed as a shared household. Post of issue notice returnable on so and so date. The petitioner shall take steps for service of notice upon the respondent by speed post within 3 working days. Para, having regard to the statements and allegations made in the application under section 12 within bracket annexer. What is the annexer?
My
No
lord,
annexer.
complaint petition was.
Hmm?
That is annexer 8 laws.
Annexer 8. And the projections made on behalf of the petition, comma, it is observed that till the returnable date, comma, the proceedings of DB case number so and so, comma, presently pending before the court of Plenary Judicial Magistrate First Class. Number 6,
Laws.
Kamrup Metro Guwahati.
First class, my lord, here is number is not there,
Okay,
lordship.
first class
Srimati Pooja Sharma, but
shall remain suspended.
all like that.
9 February.
All like that.
Item 17.
Please, my lords. This is a quashing petition, my lords, against the criminal proceedings that have been initiated against me. My lords, my case is that the allegations themselves are absurd and do not make out any cognizable offense against me, my lords. In terms of the offenses itself, ingredients are not made out, my lords. Before I get into the quashing aspects of my grounds, my lord, but my lord may kindly see the FIR itself, which has I've placed the type copy of the complaint that was registered, that was filed, which resulted in the consequent registration of FIR. The type copy of the complaint is at page 13. The FIR, the complaint was dated 8th of December 23, my lords, to which the FIR that was registered against me was only registered on 11th of December 23, and which also mentions the occurrence of offense of 12/11/23, my lords.
Hmm.
The info received otherwise, the FIR clearly mentions, is of 11/12 and of
Okay, it has already
640.
been resulted in charge sheet.
Please, my lords.
Hmm?
Charge sheet has been resulted, my lords.
Hmm.
My lords,
What is
may
the
kindly
state?
see the allegations in the written complaint that was filed against me, my lords, page 13.
What is this offense? Section 7, Drugs and Medical Remedies Act
Please, my lords.
1924.
Section 7 is the punishment aspect,
Drugs
penalty
and,
aspect of the.
Drugs and Medical Remedies Act.
Please, my lords.
What is this? Whoever contravenes
Any provisions of the Act, my lords.
any provision.
And the provisions that would be that prohibits under the Act are as per Section 3, 4, and 5 of the Act, my lords. Section 3
3.
prohibits advertisement of certain drugs for treatment of certain diseases and disorders. Very specific, my lords. Section 4 is on the prohibiting misleading advertisements of relating to drugs.
Hmm.
And Section 5 is prohibition of advertisement of magic remedies, my lords,
JJ Act.
for treatment of certain diseases, my lords.
JJ Act.
So there's a clear, my lords may see the preamble of the Act itself, what the law, what the Act prohibits. The Act to control the advertisement of drugs in certain cases, to prohibit the advertisement of, for certain purposes, of remedies alleged to possess magic qualities and to provide for matters connected therewith. This is the purpose of the Act, for which it is, in terms of the main criteria of how certain drugs are advertised, of which they would not be qualified for medical purposes. So that's the main criteria under this law, my lords. The allegation, on the other hand, completely only arbitrarily and without application of mind just simply says that these offenses are made out. In the complaint, he's listed out 7 occasions of incidents saying that where these offenses are made out against me. If my lord may kindly see the complaint again.
Hmm. So you have not appeared before the trial court?
I have appeared, my lords.
Huh?
I've prepared for a trial court, my lord.
Huh. Did you seek for discharge?
Not yet, my lords. Not yet, my lords.
You have not seek for discharge?
Not yet, my lords. My lords, I'm otherwise approaching this honorable court on the main basis that the absurdity of the FIR itself is the main grounds on which I'm seeking quashing, my lords. If I can read the allegations that I've raised, my lords.
The FIR is not a standalone FIR perhaps. It has some annexers.
No, my lords. Only the
Come to
complaint
page 14,
for,
page 14,
please, my lords. Please, my lords. Yes.
pages 13, 14, 15, 16,
Right.
17.
Apparently, they were not supplied to me at this point. But
Because it is not a standalone FIR.
that's
It has annexers.
please, my lords. These
There should
annexures
be-
have only been relied based on certain.
No, because organized, because it was quote unquote,
Yes.
right?
Yes.
Weekly healing crusade in Assam,
Right.
right?
Please, my lords.
The interpretation it may fall for interpretation whether it is an advertisement or not. Otherwise, provisions are for advertisement only.
Please, my lords.
But if it is quote unquote, weekly healing crusades in Assam,
My lords, but that will bring
and he has annexed something. Pages 13, 14, 15, 16,
these were
17.
relied by the complainant himself, who he has attached a scan disk in the charge, which is shown in the charge sheet,
So he
which
is
has
from
all
mostly
these
from
photos and
Madhurasi
everything.
background. In one of the photo, another student was saying that it is an advertisement. In one of the photos,
It is not an advertisement. That's my point also, my lords. This is extracted
it
from,
will fall for interpretation.
but it is not. That's why I'm trying to make out this point, my lords. It is not at all.
No portion. Magic Trimidi, talisman mantra. Any notice? No, let us see section 2A.
2A. Notice, circular, label, wrapper, or other document, and any announcement made orally or by any means of producing or
So it is a broad
transmitting live.
definition, not simply that
Sound of
we
music.
used to understand that putting hoarding something, something.
Please, notes. But generally, in the cases under the drugs and magic remedies, Murad, they would have
Yes.
resulted in.
Call for the TCR.
And right, the
Hmm?
Lordship has rightly pointed out, because the whole thing, if my learned friend has pointed out regarding advertisement. And these 13, 14, 15, 16, 17, it seems
Some
these
photos.
may
and-
be a
Hmm.
advertisement or. and-
Some advertisement
Yes,
was
ma'am.
there.
Because as your Lordship has pointed out, section 2A, the definition is broad. And this court, while dealing this petition right now, cannot go into
Cannot
interpretation
go
and all.
into that aspect, we'll examine.
Yes,
Please.
this court only see.
It's a matter of examination.
Please, notes.
And the definition of advertisement will fall for the consideration.
Please, notes.
And it is not a standalone FIR, just he has made allegation.
Right.
He has annexed something with the FIR.
Melrose, may kindly allow me to amend that portion.
That is up to you.
I'll-
That is up to you.
Otherwise, the FIR itself is what I was
That
going
is-
on. The
But you have annexed the charge sheet, you are not seeking quashing of it.
but even when charge sheet is filed, the FIR can still be quashed. my lord.
The instant criminal petition is preferred seeking quashing and setting aside of a first information report registered as Amguri Police Station, case number 52/2023. under sections under section 7 of the drug and magic remedies within bracket objectionable advertisements bracket close Act 1954 and section
75.
75 of the Juvenile Justice within bracket Care and Protection of Children Act 2015 JJ Act for short, and the criminal proceedings initiated pursuant there to full stop. Para it is submitted that the proceedings, criminal proceeding is presently okay, criminal proceeding of PRC case term, PRC number 21/2024 presently pending before the Court of Judicial Magistrate, Bisni. Full stop. Issue notice returnable on so and so as Mr. Kaushik 1 and 2. No formal notice. Steps upon respond number 3 by speed post within 3 working days. Comma, the scanned copies of TCR within bracket PRC number 21/2024 bracket close be called for. The prayer for interim relief is to be considered after receipt of the scanned copy of the copies of the TCR. Legible will লিখি দিব দে নহলে সব illegible আহে
4th February, 4 to
4th February. Great, friends.
item 19.
Right, please, Your Lordship, my lord. So here, my lord, PW1 has been closed, my lord, without cross-examined, my lord. My lord,
now first what is the case?
this is, my lord, the maintenance case, my lord.
Maintenance case
My lord,
2022
two, my lord.
when marriage was solemnized.
Well, marriage, my lord, there is a dispute, my lord. She, my lord, claim, my lord, maintenance for her daughter, my lord. Here, my lord, only, my lord, the trial court, my lord,
125, okay. Then notice was issued.
my lord. My lord,
Then you submitted written statement.
my lord,
Huh?
yes, my lord.
Written statement. Let us see. Which
Writ-
page?
Written is the WS in page, my lord, 18, my lord.
Page number
18, 1 8,
18.
my lord.
18.
Vernacular in page 21, my lord.
18. Annexer 2. And annexer 1 is what? Complaint.
Complaint, my lord.
That is under 125.
125.
What is the pair there? In the,
Pair.
in the application?
Application, my lord,
Let us see. Maybe please tell me the right of for maintenance to his child.
child, my lord.
Okay. Then you submitted written statement.
My lord.
When?
Written statement, my lord, on my lord.
In May 2025.
5/5/2020.
Then what is this revision petition?
Revision, my lord, filed my against the, my lord, closure of the PW1, my lord.
Okay. Let
Revision,
us see what is the statement.
my lord.
There is opposite party.
My lord, if my lord kindly come to the page number 42, my lord, the observation of the, my lord, revisional court, my lord.
No, first, what is your case projected in the revision petition?
Here, my lord, I am seeking, my lord, for, my lord, allow me to, my lord, cross-examine.
No, without looking into it,
My lord.
Mr. Counsel,
My lord,
if you, it is not a ticket counter that
my
you
lord,
put it,
my lord,
the money, and you get the ticket.
my lord.
It is not that.
Yes, ma'am. Yes,
Is it so?
no, my lord.
Then Who was PW one?
PW1 is the, my lord, the applicant itself, my lord. Here, my lord, respondent, my lord.
Okay, page 39. This fixed program. Uh-huh. 29/5/2024
My
order.
lord, my lord,
Your previous conduct is not good.
my lord. Yes, my lord.
Huh?
But, my lord,
Let us see.
my lord,
Considering the long pendency of the matter, at the same stage,
my lord,
the court on the last date has specifically made clear
my lord,
that no further opportunity beyond today would be granted to either of the parties for cross-examination.
my lord. My lord, council, my
It
lord.
is not that you put the price in and get the ticket.
My lord, yes, my lord. My
Huh?
lord, this is the fault of the council, my lord,
The
not the,
fault of the council is no excuse.
my lord, if, my lord,
CRBC has specifically provided. Now I think BNS is more strict. Petitioner is present, but the opposite party is praying adjournment, showing the ground advocate is BD in some other ground. What is the provision regarding adjournment in the BNS and CRPC?
PW, my lord.
For cross-examination, sir. We cannot interpret any provision against the
Yes,
CRPC. BNS. Yes, which is the provision?
I have to check, my lord.
Cross-examination.
Cross-examination.
How adjournment is to be granted?
242,
242, I think, my lord.
242 BNS,
yes.
CRPC.
Yes. Now, let me confirm, my lord.
Two 42, 30.
What is the provision in the BNS?
Yeah.
242.
265, I think.
242. 265. When this BNS came into force?
1st July 2023.
So it is BNS.
BNS.
BNSS.
BNSS. BNSS.
This is 265. As per defense.
BNS to learn about. Learn. Lot of years.
No, there is something more regarding adjournment.
Yes.
Is it not?
My
Mr.
lord.
Counsel? Oh,
254.3.
so your record is bad since 3/1/2023.
Oh,
Is it not?
my lord.
The-
is not
the-
254
yes, record
three.
of This perused.
54-3 of BNSS.
254-3. Whereas the after petition has reduced the evidence on affidavit, the case was posted for Hmm.
For the fair trial and interest
No,
of
fair
justice.
trial is one thing.
Hello,
Just for the concept of fair trial,
Hello, one last opportunity may be given.
254.
আমি
250.
PW প্রসব কারণে পিটিশনটা ফেলবো।
No, there is a provision that busyness of the lawyer in another court for another case is not a ground for adjournment. It is there in the CRPC, BNSS. And it is too much for about 10-15 days. The counsel was busy in another court and the opposite party was absent.
I don't agree, my
Is
lord.
it not?
But my lord,
Now let us see what is the provision. Tell me. Regarding that the busyness of the advocate for another case in another court by no stretch can be a ground for adjournment for cross-examination of the witnesses. Okay, one or two, okay, but it is 10-15 times. Is it not?
my lord, only my lord.
Mr. Kaushik,
My lord, first time, my lord, the cross-examine fixed on my lord 3-1, my lord. Then, my lord, next,
see your record,
my lord.
see your record and conduct. We don't find any. You lead defense evidence. Rebut the charge because things can be rebutted by way of cross-examination or by entering into the witness box. That opportunity is still available.
My lord, if my lord.
Because
PW is-
revision petition or criminal petition,
My lord,
it is the propriety, correctness,
okay.
right?
Every single
Or
process.
illegality.
Legal.
We do not find anything.
My lord, if my lord PW1 is not, my lord, cross-examine, my lord. My lord, the.
But cost will be very heavy,
Cost?
50,
No,
then it is dismissed.
my lord, my lord, my lord, he is the my lord, very poor person, my lord.
4 counts a person engaging
Any matter-
advocates for 15 days continuously for seeking adjournment is not a poor person. You
Well-
enter into the witness box, rebut all the allegations made by the
On the
PW1.
Section 309, if I'm not, CRPC.
Yes. Okay. CRPC.
D. D. Explanation B.
The fact that the pleader of a party is engaged in another court shall not be a ground for adjournment. And all these conditions are there. It is a general provision
My lord, petitioner
for
ready,
as to inquiries and trial.
petitioner ready to pay 3,000 rupees.
Huh?
3,000 rupees ready to pay.
50,000.
My lord, 50,000 is very heavy.
Then you forget.
Well, 5,000, my lord. Kindly, my lord.
There is no illegality. Absolutely no illegality.
But
Why should we bother about it?
Petitioner is
Because we are only considering correctness.
well, only last opportunity, my lord. Kindly, my lord.
No, last opportunity have been granted many times. Is it not?
My-
Hmm? There cannot be last.
Ready to pay, my lord.
One last, next, second last, third last. Is there anything in the dictionary? No.
No, last opportunity, my
No.
lord. Kindly, my lord. Maybe.
Nothing was there.
So he ready to pay, my lord, 5,000 rupees.
You go for the.
Kindly, my lord.
No kindly, no correctness, illegality or impropriety. And particularly, a second revision does not lie in the guise of 528. Part, Mr. Gwala,
My lord.
learned counsel for the petitioner. Post of. Okay, Mr. You are not a party. We'll issue notice. Issue notice. The petitioner has preferred the instant criminal petition under 528 BNSS against an order dated 18/11/2025 passed by the Court of Additional Sessions Judge FTC Sunitpur at Tejpur in criminal revision number 20/2024, whereby the revisional court rejected the revision petition preferred by the petitioner against an order dated 18/11/2025 passed by the Court of Subdivisional Judicial Magistrate S. Sunitpur at Tejpur Trial Court, Postop, by the order dated 18/11/2025, the trial court closed examination of PW1 cross-examination of PW1 by the petitioner for the regions recorded therein in a proceeding instituted under section 125 CRPC by the respondent seeking by the respondent, MR case number 2/2022, seeking maintenance for a minor child. Post of issue notice returnable on say February 3rd. Steps register post. 3 working days.
Pavlaj.
Being a very getting advocate, it is BAS 2C.
So you put it in your memory
It's not going for.
so that I cannot have to go through the provisions. Next.
For admission, item number 21,
Yes, Mr. Mondal,
my lord,
why you have come after 9 years now?
Yes.
What is this case?
This is regarding my lord, government employee who has been my lord, implicated in a-
অপরাধমূলক আজি দিনৰ পৰা 11টা বজাত অপৰাধমূলকভাৱে বিশ্বাস ভংগ কৰি চৰকাৰীভাৱে বিদ্যালয়ত দিয়া মধ্যাহ্ন ভোজনৰ চাউল অসৎ উদ্দেশ্যে বিক্ৰী কৰি আত্মসাৎ কৰিবলৈ লাঙিনা ঠেলা গাড়ীত 7 বস্তা চাউল বিক্ৰীৰ বাবে নিয়া অৱস্থাত মই মোৰ বৰঙা মহিলা চৰকাৰী সদস্যক হাতে লুটে ধৰা পেলাওঁ ঠেলা চৰৰ লাঙিনা বিক্ৰী কৰি ওলাই দিছে আব্দুল সত্তাৰ আহমেদ Moinul Haq. Then after the FIR, any charge sheet?
Yes. Now, since my lord, the
Who
petitioner
is the
is the
charge sheet?
government employee, my lord,
Ah. Hmm.
so provision of section my lord, 197 is attracted. CRPC. That is the only case, my lord. So since today is my lord, for admission, my lord, let it be admitted and let it be fixed for any.
No,
day-
question is very simple now.
Yes.
406, 409.
Yes,
Prosecution sanction is required or not required?
yes, that is,
Right?
yes,
Now, when it is required? In discharge of his official duties or
Yes.
purportedly in discharge of his official duties?
that is,
Whether this act
Yes.
comes within that provision of 197, I think that is the
yes, that has to
So-
be, but
that happened. There are a long line of decisions.
yes.
You show any of
So,
them,
my lord, may I?
any
please,
of
my lord,
them
Yes.
that
my lord,
the rice which is meant for
yes,
midday meal
yes,
is surreptitiously taken out and carried to another place is part of the official duty or purportedly in discharge of official duties. That is the only issue.
yes, that is only,
Whether for that purpose sanction is required or not required.
yes. That is there. So, my lord,
You come from that, you start from the decision of that Punjab state chief minister. What is that?
my lord, today, my lord,
Huh? Who is that? Singh?
my lord, today I have some personal inconvenience, my lord. May I pay any day, my lord,
Thursday.
Thursday, my lord?
You start from that Punjab
Yes,
state chief minister. Sanction required or not required. For a chief minister, everything is the official duties,
my lord,
right?
yes,
On the prayer of Mr. M.E. Mondal, the Kasaragod petition, at least the case on Thursday.
8-1.
Mr. MP Gustami, Leonard, additional public prosecutor for the respondent state is failed.
deep blood plus.
What is that decision? Some Dhillon or I forgot. Anyway,
Item 22.
Maybe. Principal is statutory appeal, my lord, is under
agreeable.
Right.
Heard Mr. Rashid, Leonard counsel for the accused appellant, and Mr. MP Gustami, Leonard additional public prosecutor for the respondent number 1, state of Assam. Full stop. This criminal appeal under section 415 B and SS is preferred against a judgment and order dated 7/11/2025 passed by the court of arising out of Sidley Police Station case number 11 of 2025 passed by the court of Special Judge Shirang Kajalgaon Special Court. In special Poksho case number 24 of 2025 posted up by the judgment and order dated 7/11/2025, the special court has convicted the accused appellant for the offense under section 4 1 POCSO Act and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 20,000 with a default stipulation. First stop. I've gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. Let TCR be called for, issue notice, returnable in 4 weeks. As Mr. Goswami has appeared accepted, as per number 1, no formal notice is necessary. The petitioner shall accuse appellant shall take steps for service of notice upon the response number 2 in terms of the practice direction notified by so and so. Full stop. The additional public prosecutor is to obtain a report as regards service of notice upon the response number 2 from the officer in charge, Sidley Police Station, to place it before the court on the returnable date.
Item 23.
On prayer, my lord, because I have not filed any application for bail. So as soon as the LCR comes, it will be placed for hearing.
You file an application.
After. Well,
Anyway, the informant is to be served.
after serving.
Thereafter, you file. Yes,
May I please, Your Lordship? This is a criminal appeal, history appeal, Lordship.
heard Mr.
R.L. Sutia.
R.L. Sutia, learned counsel for the accused appellant, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent number, accused appellants, for the respondent number 1, State of Assam. This criminal appeal 415 BNSS is preferred against a judgment dated 18/11/2025 and an order on sentence dated 20/11/2025 passed by the Court of Sessions Judge Udalguri, Assam Trial Court in Sessions within bracket T-Roman capital 2, case number 18/2025, full stop, by the judgment and the order on sentence, both the accused appellants have been convicted for the offenses under section 305 within bracket small e stroke or read with section 3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. Full stop. For the offense under section 305 against the conviction, the accused appellants have been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 10,000 each, in default of payment of fine, to undergo simple imprisonment for another month each. Full stop. I have gone through the grounds urging the memo of appeal. The criminal appeal is admitted for hearing. That TCR be called for, issue notice, returnable on so and so. Who is respondent number 2?
Informant.
Informant. Okay, 305 is what?
Theft.
Theft. Okay. MP Goswami, respondent number 1. Steps upon respondent number 2, speed post within 3 working days. Yes.
I is there.
Yes, Mr. Goswami. Regarding,
5 years.
what is your ground?
5 years conviction, man.
5 years conviction. You were in custody
Yes, Lordship.
since when?
Since Lordship, 200 days, Lordship.
That I have seen.
Mm,
Presently,
Almost 1 year pass.
Huh?
1 year maybe pass. 10, 11, 11
when is the order on conviction?
order,
Where is the order on sentence?
main case, Lordship, last page number 26. The period of 200 days.
What you have theft? What?
Lordship,
The allegation is against you.
my
You
allegation is
committing theft of what?
tower material.
Tower material.
Tower.
Night, come on, is a theft of remote radio unit installed in the tower top of.
RRU, remote radio unit.
Looking downstairs. Private property.
Private property, sir, not attracted to T05E Lordship.
Hmm? How?
T05 is not attracted.
305 is not attractive. Why?
Five. It is not a government property or
Theft is for every property.
T05E Lordship. Of any property of the government or of a local authority, Lordship.
Wrong conviction. But private property,
Private property, Lordship, but they not pass judgment in the another.
tree dwelling house. Tent or
That's what you
vessel,
said, so.
limited or used for the custody of property.
A may be attract T05A maybe.
A, conviction is same, sentence is same,
Sentences.
used for the custody of property. So, from tower means it would include. What is the weakness in the prosecution case?
I am not reduce defend witness. Lordship.
If there is no weakness, sir, then it will be better to convert it to period undergone. What is the weakness?
Page 21 is approved.
Page 21.
Yeah.
Anyway, it was 18 number says fixed period. But Mr. So-and-so, learned counsel for the applicant appellant, R.L. Shutia, and Mr. M.P. Goswami, learned additional public prosecutor for the opposite party, just responding state closed up written application under section 430 BNSS, seeking suspension of the execution of the sentence passed against the applicant's appellants and for their release on bail. First of para. The applicants as the appellants have preferred the accompanying criminal appeal number so-and-so against the judgment in an order on sentence dated so-and-so in Likidibu. Para. It is noticed that during the period of investigation and trial, inquiry trial, the applicant's appellant spent a period of 200 days in custody. Full stop. On the date of passing the impugned judgment on uh, 18/11/2025, the applicant's appellants were taken into custody and the order on sentence was passed on 20/11/2025. Full stops. Since 18/11/2025, the applicant's appellants are in custody till date. Full stop. Para. The learned counsel for the applicant's appellants have pointed out, have pointed out that there are certain discrepancies and gaps in the prosecution case which should entitle the petitioner. for acquittal, at least on benefit of doubt. Post moreover, the petitioner spent, sorry, appellant have spent more than 250 days in custody till date. Post he has further submitted that the alleged theft was not in connection with any property of the government or of a local authority, and the same would not attract the offense under section 305E. Post of প্যারা ইয়ারে প্যারা 6 টু লিখে দিব, প্যারা 7 টু লিখে দিব, প্যারা 8 টু লিখে দিব, প্যারা 9 টু লিখে দিব, 20,000. 50,000.
Otherwise, my direct evidence. Otherwise, my direct evidence is there, my W1.
Okay. Fixed sentence. At least 250 days they have spent.
Item 25.
May I plead the lordship? This is a criminal revision petition against an impung order dated 30/10/2025 passed by the.
Yes.
Okay.
Any. Oh,
Order
it
date.
should have been in the motion column perhaps.
25.
Huh?
Six.
You get a report. What is the offense? 303 means what?
303.
Murder,
No, your lordship, theft.
theft.
The vehicle behind the police station since last 6/1/2025,
Oh.
your lordship.
Have you approached the trial court?
Yes, your lordship.
Where is that order?
Page number 23.
Page number 23. Stolen kettle.
Yes, your lordship.
And okay, is given in Jima. And where is the affair?
FIR that,
You are Amjad Ali.
yes, your lordship. Page 10.
As filed is application for 82 for his values in assess. What is the vehicle?
Maruti
Espresso.
Expresso, your lordship.
Espresso is what? This
Car.
small,
Small one.
alto kind of thing.
Okay.
You put the kettle there, 2 kettles.
I am, I was not there, your lordship.
Oh. So you took the 2 kettle for a ride there.
My driver,
Get a report. Heard, Miss.
in the last occasion, the report was called, your lordship.
Oh, call for a report, yeah.
Also, it is.
Okay,
Okay.
not received. Get a report.
The vehicle behind the police station since 1 year, your
Wait
lordship.
for 14 more days.
The two numbers of kettles were recovered.
We used to see
But
dogs inside the vehicle,
Vehicle.
here cattle, instead of dog, they were taken for a ride. Heard, Miss?
HG Daisy.
Learned counsel for the petition and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Full stop. Mr. Goswami has submitted that a report as called for by order dated 12/12/2025, has not yet been received. Full stop. And has submitted that matter be posted on so and so in order to enable him to obtain the such report. Full stop. List the case accordingly on so and so. When? You tell me.
the 24th.
24.
20. Saturday.
Sorry.
22nd.
Obliged.
Item number 26 with 44.
What is this, sir?
Wait, please, your lordship. My lord,
And
this is a criminal
scan
petition for.
copy, PCR. Just to remind us, the scan copy of server. What is the
So
issue?
June, I filed, my lord,
Ah.
this case. Then, my lord, notice was issued.
I
and-
bigger than the main petition or what?
That is why, my lord, because TCR was called for in the month of July last year, my lord. And
Huh.
it has not come. That is why I have placed the statement of the witnesses by way of this IA, my lord. I have to file this IA because, my lord, the trial of that case is proceeding. And, my lord,
Official case number so and so. What is the case about?
my lord, section 7B.
What is the prayer?
Prayer, my lordship,
Quashing.
quashing, my lord.
Charge under section?
7B, 120B, 7B, and Police Act, my lord.
Hmm. Where is that?
That, my lordship, will
Order.
find at page 90.
90. Or the main petition?
Charge, my lord, 101
Hmm.
against me, my lord. There are 4 number of accused persons, my lord.
Okay.
And charge that has been framed against me is 101, my lord. Charged with 3 heads.
Hmm.
Firstly, 120B. Secondly, my lord, 7B of PC Act. Coming, my lord.
Now,
And
when is the
TCR would
next
be-
date?
Next date is 12th February, my lord.
We'll
And-
put it on 27 January.
But, my lord,
Hearing date.
but TCR would be required, my lord.
Again, we'll ask for it.
It is not coming since, my lord, July. And, my lord, there is, because my learned friend has said that honorable.
Or
Apex-
we'll make use of your eye. If
My
that is
lordship.
sufficient.
My lordship,
If
because
Mr.
other, my lord, this is a case of documentary evidence, my lord. And apparently I'm taking a risk in this particular case. Why I am submitting, my lord? I am prior hand disclosing my defense story. And, my lord, taking a risk before this honorable court. Why, my lord? Because apparently from the perusal of the records, my lord, there is no, my lord, materials indicating my complicity in this particular case with regard to, my lord, demand and acceptance of, my lord, illegal gratification, my lord. So far as this particular petitioner is concerned, my lord. That
Okay.
is why I have taken the
When
risk.
for the first time it was asked for the scan copy?
July, my lord. 18/7/2025, my lord, last year.
18/7/2025.
And there are 7, my lord, office notes, my lord. 6 office notes, I'm sorry, my lord.
18/7/2020. 18/7.
My
That
lord.
was for the first time.
No, my lord, earlier June, my lord, notice was issued.
The
Because-
scan copy is for second, third. Second occasion. Okay.
At this juncture, my lord, my only, my lord, prayer would be, my lord, till the PCR comes, my lord.
At
the-
least this court does not make any order of stay unless it applies its mind, at least on the privacy materials.
Yes, my lord.
So let us have it on 27. Nothing is going to fall. Heaven is not going to fall before
For con-
12th of February. Is it not?
For consideration of interim, my lord,
Ah.
if, my lordship.
No, we'll go whole hog. This is not a case of interim. Agorgan, one query, response number 2 informant.
27 for orders.
2017 matter. For a 1 week time is granted.
Item 27.
NS Mazhar Bhuiyan. No step taken since 2017. We put it on tomorrow. We'll give one chance. Thursday ko jo. None has appeared for the petitioner. Today on call. Post of Para. Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam is present. Post of Para by order dated 26/7/2017 comma, this court, while issuing notice, comma, directed the petitioner to take steps among the respondents, full stop. When the petitioner did not take any steps in deference to the order dated 26/7/2017, full stop. When the case was listed again on 7/1/2019, comma, further 1 week time was granted to the petitioner to take steps as per order dated 26/7/2017, full stop. As per office note dated 30/10/2025, comma, no steps have been taken by the petitioner for service upon the respondent number 4 since 26/7/2017 till date. Full stop. The petitioner, the counsel for the petitioner is also found absent today on call. Full stop. Though the names of the learned counsel for the petitioner names are reflected in the call list. Full stop. Para. The CR question cannot be set aside. Jasmine in order. Whether criminal revision petition can be dismissed on default. That is why. How much merit is to be discussed? Let us see the nature of them. Something is laid down somewhere.
In the law, I have. That
Criminal appeal, you have to appoint an amicus. In revision petition, what is the law? $60 lakh properties were destroyed. Eviction order, eviction operation on the basis of specific order of the High Court, which did not include the name of the petitioner and other members of the evidence, from copy of the notice issued in enforcement case number sunset, the time petitioner was involved claim for which the Deputy Commissioner seeking details whether having failed to he filed a complaint in the court of science which is registered as science of case was transferred. This is what on. Oh, lack of prosecution sanction. Complaint petition was filed against definitely government officials who carried out eviction operation pursuant to High Court direction. And according to the petitioner, their names were not included in the order. But in spite of that, their properties worth for 60 lakh was destroyed. prosecution sanction is a must. Do you have the record? Okay, go through the second copy or second copy, second nine, nathake, no? Nathake. So in a complaint case, 447, 448, 427, 506, 34. All are against additional district commissioner, circle officer, and Sarkari Gambura, right? So complaint was filed against them. So that is the issue. Prosecution sanction was not there. So it is a condition precedent to proceed further. So what is the ground?
What stage?
No, cognizance this. Cognizance this. Very beginning. Per parted. Okay, in view of non-representation on behalf of the petitioner today on call is the case on Thursday.
8.
That is the only one issue. Power party discharge of their duties. So condition precedent is a sanction under section 197 CRPC. Since it was not there, so complaint petition was dismissed or not dismissed due to lack of prosecution sanction. So we have to decide on merit. Get the how the revision petition is to be disposed of. Secondly, prosecution sanction. Thursday. No record. The issue is simple.
Item 28.
By this application had challenged a judgment on a session judge criminal appeal. GR case number. आया से नहीं गिवा आया to dispose of हुआ बेलर আছে না council Mr. Rashid was there in one criminal appeal. Mr. Rashid was there.
Yes, earlier.
Oh. Okay, there is no representative on behalf of the petitioner today on call. This is against conviction. Mr. MP Goswami, learned additional public prosecutor for the respondent state is present. So, in view of non-appearance, non-representation on behalf of the petitioner, today on call, let the case, for of justice be listed on next video.
28. Item 29.
I have seen. None appears. Neither any step. Email petition. Huh? No step. Dismiss. There is no representation on behalf of the petitioners. Today on call. First up, Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam is present. First up, the criminal petition under section 482, criminal Code of Criminal Procedure 1973 is preferred, seeking quashing and setting aside of a charge sheet charge sheet number 43/2017, dated 29/4/2017, submitted in connection with Botodroba Police Station case number 62/2017, within bracket corresponding ZR case number 1723/2017, bracket close, are registered under sections 395/427/406/506/34 Indian Penal Code, read with sections 4/5, Assam Land Grabbing, within bracket Protection, bracket close, Act 2010. Full stop. The charge sheet was submitted. Finding a privacy case established against the petitioners for the offences under sections 447, 427, 506, 34 IP6, read with section 4/5 of the Assam Land Grabbing Act. Full stop. Para. This code, while issuing notice on 1/11/2017, the petitioners were directed to take steps upon the response number 2 within 5 days from 1/11/2017. Post of no steps were no, like the notice sent to the response number 2 was returned unserved as per office note, as per office note dated 6/2/2018. Post of on 9/2/2018, the petitioners were asked to take fresh steps for service of notice upon the response number 2 by registered post with AD within a period of 5 days at his correct address. Post of. But the petitioners since 9/2/2018 did not take any fresh steps for service of notice upon the response number 2 at his correct address till date. Post of. When the case was listed again on 17/6/2019, none appeared for the petitioners. Post of. Para. In view of the above facts and circumstances, fact situation obtaining, this court is persuaded to take a view that the petitioners are no longer interested to pursue the present criminal writ petition. Post of. Accordingly, this criminal petition is dismissed for non-prosecution.
Yes. Item 30.
Yes.
May I please have it? In this matter,
The appeal is admitted, call for LCR. LCR received.
LCR
LCR
man.
Okay.
fixed for hearing.
Appeal fixed for hearing.
Hearing man.
Heard, Mr.
M. Hassan.
M. Hassan, learned counsel for the appellant, and Mr. MP Goswami, learned additional public prosecutor for the state. Respondent state. As the TCR has been received, and comma, the appeal has been admitted and the respondent is represented, please the appeal for hearing in the usual course.
Item 31.
Ratnajyoti Hoikia. Jail.
Jail appeal, my lord.
Perhaps
D. Sakia is appointed, my lord.
it has been changed.
Change.
It has been
Uh,
changed.
Yes.
She
yes, that
she
has
has
to
been
be- yeah,
inducted
yes.
the
Yes.
grade 1
Yes,
judicial
my lord.
service.
Last occasion it has been changed, perhaps, my lord.
Amicus.
Oh my gosh.
Yes, Mr. Ujjwal Chaudhary. Okay. Mr. MP Goswami Learned Additional Public Prosecutor for the respondent state has submitted that Ms. D. Soikia, who was earlier engaged as amicus curiae to represent the appellant, has since joined the judicial service
Yes.
and therefore, a new amicus curiae is to be appointed to represent the appellant. Stop. Mr. Ujjwal Chaudhary, learned counsel, who is also an empaneled counsel, is appointed as amicus curiae to represent the appellant, post of registry, to furnish the requisite case papers to Mr. Chaudhary within a period of 2 weeks on today. TCI is release the case after 2 weeks. You report whatever you have received on
32.
Yes, sir. Appeal is admitted, call for trial court record. Served but none has appeared. Directed to appoint amicus. Okay,
My lord, sentence has been suspended, so for hearing.
usual course. P.K. Roy Chaudhary, learned counsel for the appellant, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent state. Full stop. Mr. S. Das has already been who has been appointed as amicus to represent the respondent number 2, is also in attendance. Full stop. As TCA has been received and the appeal has already been admitted for hearing, and both the respondents are represented. Office to list the appeal for hearing in the usual course.
Item 33.
How much?
Lordship, 1810 days.
One, and we have to issue notice at least for the sake of formality.
Lordship.
Oh,
Otherwise,
okay,
it is a
notice
case of-
issued.
Yes, Lordship. But from the office note dated 13.
What happened to respond number 2?
Yes. Otherwise, it is a case under 304 part 2, and he has been examined as PW1 in the case. Inadvertently, I made him a party in the case, otherwise not required.
Not required.
Yes, 304 party, it is not compulsory.
304?
Part 2, Lordship. 10 years he was
10
convicted.
years.
Yes.
And what is the date of the judgment?
Lordship, the date of the judgment is 2/2/2019. And
How much period you have spent?
Lordship, I am behind the 4/2/2018 from the date inception from the FIR.
How much period?
Lordship, total it will be 10 years. 25.
A longer conversation.
Condonation to know. Behind the bar, Kima.
Behind the-
Lordship wants to know behind the bar total.
Because otherwise I have to file objection, my lord, because 10 years
And
for
Bail no.
regarding bail.
No, delay.
Delay,
Only delay.
delay.
Not suspension.
Lord.
Suspension no delay.
It is a process towards suspension.
Lordship. Delay.
Delay. Can
1810.
1810.
yes.
So 1810 plus some more days,
Some,
Some
in-
more days.
yes, some more days.
some more days, plus whether in the, earlier, I don't think that there is to be the column.
Lordship. In the judgment, there is no such column.
Yes,
Lots.
regarding delay. You have not filed any objection
No.
No.
since 1.5 years. So
Then
impliedly you have consented.
I'm not filing my verbal objection. My lord.
I heard Mr.
Delay.
U. Chaudhary, learned legal aid counsel for the applicant, and Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, comma, State of Assam, full stop, para. Those steps were taken for service of notice opposite party number 1, day. For service upon the respondent number 2, there's informant,
Informant.
comma, both Mr. Chaudhary and Mr. Goswami have conjointly submitted that since the conviction of the applicant is under section 304, part 2
Part 2.
IPC,
Yes, Lordship.
service of notice upon the informant is not mandatory. And the service of notice upon such informant can be waived.
Lordship.
Full stop. Para. The instant application under section 5 of the Limitation Act 1963 is preferred by the applicant seeking condonation of delay of 1810 days, comma, which period of delay has occurred in filing the accompanying criminal appeal under section 374 within bracket 2 of the Criminal Procedure Code 1973, post of para. The comma, which is yet to be registered. Post of the accompanying criminal appeal is preferred against a judgment dated 2/2/2019 and an order on sentence dated 6/2/2019 passed by the Court of Learned
Additional session judge.
Additional Sessions Judge FTC, Jorhat Trial Court, in Sessions Case number 74 of 2018. Full stop. In Sessions Case number 74 of 2018, the petitioner or the applicant was arraigned as the sole accused to stand in the trial for a charge under section 302 IPC. Full stop. After conclusion of the trial, comma, the trial court had convicted the petition applicant by the judgment and order on sentence, comma, mentioned above for the offense under section 304, comma, part 2
Part 2.
IPC, and the applicant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, comma, in default of payment of fine, comma, to undergo simple imprisonment for another 5 months. Full stop. The period of detention already undergone has been directed to be set off. Full stop. Para. The Mr. Goswami, Chaudhary, Legal Aid Council, appearing for the applicant, has submitted that since
4/2/2018, he is. 4/2/2018. Lordship will find it in page number 2 in the cost
Okay.
title. In
date of, not in front of the date of judgment.
no,
Huh?
from because it is a legal aid. It was no one in the reason of Lordship will find in the reason also. Reason of delay, he has stated that there is no one to file an appeal. So
No,
he's
you are in custody since
yes.
the date of judgment or
No, from 4 to
4 to 2019. The petitioner has been, applicant has been undergoing the sentence. Full stop. Mr. Chaudhary has further submitted that during the period of investigation also, the petitioner was in custody,
Lordship.
right?
Lordship.
Full stop. He has further pointed out that the petitioner has spent about 6 years of his 10 years period sentence as on date. Full stop. Para. What is the reason?
Lordship. The ground is basically in paragraph number 4, Lordship. The
I
annexure,
have gone through the statements and amendments made in the instant interlocutory application, more particularly, section 4 thereof,
4 and 5, Lordship.
4 and 5 thereof. Full stop. Para 6 to लिख दीजिए यार. It will be. Here is para 6 to लिख दीजिए. An appeal is indisputably a statutory right. An offender who has been convicted is entitled to avail the right of appeal, which is provided for under section 374 CRPC. So, right of appeal from a judgment of conviction affecting the liberty of a person, keeping in view the expensive definition of Article 21, is also a fundamental right. It has been observed in Rajendra versus State of Rajasthan, 1982, 3 SCC, 382, that where the appellant furnishes reasons for delay in filing the appeal, the court would not dismiss the appeal as time barred without examining the reasons for delay. Full stop. Para section 5, it will लिख दीजिए. It is evident that the applicant has already spent 6 years in custody to serve out the sentence of 10 years imprisonment. Full stop. Tarpichot para 6 to likhi dibo. 7 to likhi dibo. A more order. Yes.
Obliged.
Item 34.
May I place your Lordship? Lordship, LCR has been received. Matter may be fixed.
Appeal 415. Okay. Only responding the state respondent.
Only state.
Okay.
Yes,
Mr.
1 year, my lord.
Mr. S. Day, behalf of Ibu Sharma.
S. Day, Learned Counsel for the appellant, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state. Full stop. The TCR has been received. And state is represented by the learned additional public prosecutor, who established the appeal for hearing in the usual course.
35,
Me, please.
Yes, madam.
156 days delay for filing the criminal appeal, my lord.
Is it?
Because judgment was delivered so long time, sir. I have received a certified copy.
419 BNSS.
Yes, ma'am. It is the NI case, my lord.
NIA case.
NI.
By whom?
I am the on behalf of the complainant, my lord. Complainant, my lord.
Oh. Then we have to issue notice. Private case.
Private case, my lord.
Heard Miss R.
R. Puritam.
Learned counsel for the petition. The instant application is under section 5 of the Limitation Act, seeking conversion delay of 156 days in preparing the accompanying appeal. Issue notice returnable. On so and so. The applicant to take steps for service of notice upon the opposite party by speed post within 3 working days from today.
6 February.
6 February.
Item 36,
May please, your lordship. Lordship, this is a criminal leave petition seeking leave to appeal against the judgment and order of acquittal passed by the learned additional session judge 1, Kamrup Metro. Matter pertains to an NDPS case.
Acquittal,
Yes, lordship.
19/6/2025.
Yes, 2025.
19/6.
Yes, lordship.
Leave granted or what?
Yes, lordship.
Leave granted
Leave may be granted.
already.
No, not granted.
Huh?
This is the first.
It's 5 years. Okay, criminal leave petition.
Yes.
Okay.
Today has been listed first
Uh,
for this honorable court.
19/6. Then
Yes,
whether it is within time.
Yes, within 6 months, lordship. Since
6 months.
yes.
Okay. Mr.
K. Brook.
K.
K.
Brook.
Brook, Junior Standing Counsel, DRI.
Okay, Learned Junior Standing Counsel, DRI, for the applicant first of the instant criminal leave petition is preferred under subsection 4 of section 419,
BNS.
read with section subsection 5 of section 419, subsections likhibo 4 and 5 of section 419 Bharatiya Nagorik Suraksha Honita, seeking leave to prefer an appeal against a judgment and order dated 19/6/2025 passed by the Court of Learned Additional Session Judge Kamrup within bracket M Guwahati Trial Court in MDPS case number 27/2020, which arose out of DRI seizure case, not like a full stop, by the impugned judgment and order, the trial court has acquitted the opposite party from the charges under sections 8 post title C, 21C, 22C, 23C, 25, 27A, and section 29 of the NDPS Act. Issue notice returnable on so and so. The applicant shall take steps for service of notice upon the opposite party by speed post within 5 working days from today.
Deeply obliged, lordship.
item 37,
My lordship,
Instant criminal petition.
lordship, as per Krishna dated 23/12, service is not yet complete.
Okay, Mr.
NZ Chaudhary.
NJ Chaudhary,
Yes.
Learned Counsel for the petition, and Mr. MP R.R. Kosik, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, are present. Post up. Peruse the office note dated 23/12/2025. Post up. Await for a service report in respect of the respondent number 2. Post up. List the case on February 2.
Of lordship.
Item 38.
Minute to your lordship. Mala, there is a IA.
I for what?
Mala, your lordship, I turn to page 20. Your lordship will, there is an order of your lordship. Page 20. In the IA.
WBC.
In WPC and Mala, in a criminal petition, we have challenged the proceeding of a complaint case. There was a stay order. After the stay order, the certified copy was placed before the trial court. Trial court thereafter issued non-bailable warrant.
Okay,
of arrest.
1 minute. What is this criminal petition?
My lord, a complaint case was filed, my lord, your lordship will turn to page 8, annexure 1. A notice was sent to my client that I have taken 7 lakhs of rupees as loan.
No, here an interim order is operating.
Interim order operating, your lordship in the IA will turn to page 12.
1 minute. Interim order 1 minute.
Page 12, my lord, the interim order passed in criminal petition is at page 8.
And what about service?
My lord, as regards service, I have taken through the police, I have taken through everybody, my lord. Then, my lord, as regards paper publication, my lord, the only son of the petitioner expired, the daughter was for transformation of kidney. That is why the paper publication could do. I have done all of the registered posts, just the OC, everything has been done, my lord. The address given,
Newspaper, the newspaper on which publication is required to be made. Okay, direction was made there, something, newspaper,
newspaper.
by subsidiary mode.
But only because of the financial condition, I could not ask. Malad, because the lady is retired and her only son expired, then my daughter has to go for change of kidney in Calcutta.
But once that order is in pass, how can it be recalled?
Malad, only thing is that, Malad, I will ask for some time to go for paper publication, later return. Only thing, Malad, that interim order in the IA that was passed in writ petition, that has to continue, Malad, that much. In the IA, and I will, Malad, take steps in the IA through, Malad, registered post again.
1 minute.
In IA, your lordship may turn to page 12. First page 8, the interim order passed in criminal petition. A complaint case was filed only because the 3 years was over. If the allegation is found to be true, that some loan was provided and the money was not returned. After 3 years, she files a complaint case. Then thereafter, my lord, I appeared, I took bail, then I came.
Yes, Mr. You are responsible to hire Mr. P.K. Rachuri and counsel for the petition. What execution of the order? What is that? 2010-2021? What is that order?
Page 12, my lord, in IA.
Page?
12.
Okay.
My lord, in IA, your lordship will find on 6/12/19, the complainant is absent with steps by petition dated out considering the prayer of the stands allowed, showing cause. The counsel accused submitted a certified copy of the order passed by the Honorable Guwahati High Court in connection with criminal arising out of the peruse the same. The Honorable Guwahati advised aforesaid order continue the earlier stay order, fixed for necessary order. That was after the stay order was provided to the trial court. Then, my lord, at page 13, non-bailable warrant was issued. When that TM has been transferred. That was stayed in a writ petition.
Stayed in a repetition.
Stayed in a writ petition. Then your lordship also said a judicial order cannot be challenged in a writ petition. So that liberty was given to me, file a IA. So I have filed a IA in the criminal petition, my lord. So that interim order, that
Steps.
in the writ petition, that order was at page
Certified copy on the order 30/10/2019. What is the 30/10/2019 order?
30/10/19, page 10, my lord. In the IA.
You have jumbled up the every fact, huh? You file writ petition against.
Writ petition was against that order, my lord, when after a stay order was provided, the judicial court passed a non-bailable warrant of arrest. And the interim order was at page 8.
23/2021. By which order 23/2021 was stayed?
23/2000. My lord, that is at page, my lord, 16.
Okay, so. Okay, we'll pass the order tomorrow. List the case tomorrow. There are so many jumble of facts. And at this stage, it is very difficult. A mess has been created.
Mess has been created. Because of my fault, my lord, because that aspect that a judicial court order cannot be stayed by a writ petition. Then your lordship gave me a liberty to file a IA. That is why I am with this.
That is why list the case tomorrow.
My lord,
Okay.
interim order to continue till tomorrow. My lord.
Interim order pass that.
Because
If
other-
any, if any.
Your lordship
Sure.
given that till the date of listing
If any, shall continue.
or day after tomorrow, but it will not be listed tomorrow. Day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Let it be on Thursday.
Thursday. 8 will.
At the end, it is very difficult to apply my mind.
Mal.
So many jumbled up facts.
Yes, yes.
Mal.
Yes, madam.
Lordship, I
What is the petition about? Hard miss? You come this side.
mentioned to item number 39.
Yes, why?
Pass over the matter for a day as my senior is out of station today.
Hard miss? I've asked you to go through the case. It is, I have requested you at 10:30 to go through the case and to make submission. Not to repeat the same prayer. Yes, what is your name?
My name is Darashmi Datta.
J. Dr. Learned Counsel for the applicant. And Mr. R. Kosik, Learned Additional Public Prosecutor for the opposite party number 1, State of Assam. This is an application under section 5 of the Limitation Act 1963, praying for consideration of delay of 1876 days in filing the accompanying criminal revision petition. Issue notice returnable on so and so. The petitioner, as Mr. Kaushik has appeared and entered appearance, opposite party number 1. No formal notice. The applicant shall take steps for service of notice up in the opposite party number 2 by speed post within 3 working days from today.
Number 40.
May I please the lordship? My lord, in this IA, my lord, there is a 136 days, my lord, delay in filing his criminal appeal, my lord.
Against conviction.
Yes, my lord, conviction, my lord.
Conviction.
Judgment and order dated 23/05/2025 passed by the learned additional session judge Udalguri in criminal appeal number 0725 affirming the judgment and order dated 21/12/2024.
Oh, this is revision petition.
Yes, my
And
lord.
it has to be a revision, that is what,
Huh?
it is as per criminal appeal, my lord, but has to be converted, my lord, otherwise review. Because the, my lord, conviction is affirmed by session judge, that has been
How
passed
can
by.
it be criminal appeal?
Review.
My lord, the appeal,
It
If it is the order impugned is passed in appeal,
has passing appeal.
there cannot be second appeal like CPC
Yes.
in criminal case. And what is the case about?
my lord, in this case, my lord,
Register police case.
yes, police case, my lord,
Police
GR
case.
case number
Police case,
902
my lord.
and conviction rigorous imprisonment
Okay,
for
we are
1
not
year.
into conviction, we are into the procedure
Procedure.
at this stage.
GR case, my lord.
GR case,
Yes.
conviction affirmed.
Yes.
What is the connecting provision in BNSS for revision? 430. What are they?
8, my lord.
8.
My lord, in this case, appeal, my lord, the petitioner appeal.
1 minute,
has
1
come to
minute,
the
madam.
court.
1 minute, madam.
Oh.
What?
My lord, the appellant petitioner has approached to the legal service authority for filing a criminal appeal, my lord, against the judgment and order.
No, that means a layman. But
Yes.
Miss B.R.A. Sultana is a seasoned counsel. Is it not?
Yes,
Layman, you go for why the legal assistance is required to a layman, a poor person litigant under the Legal Services Authorities Act. You make another application. Why should we enter it? Legal counsel making this fatal kind of mistake is not permissible. That is a layman. So If she wants an SLP before High Court, you will file an SLP before this High Court. Special petition. To go by the
So your lordship.
litigant,
Your,
make an appropriate application to convert it to revision.
so your lordship
Yes.
kindly allow this appeal to be converted to a
You
revision
file an
petition.
application.
Yes.
Legal learned lawyer committing mistake is not permissible. Then why you have been engaged as a legal counsel? Because you are convergent with the law.
Yes, my lord.
Don't throw everything to the court.
Yes.
Otherwise,
Yes, my lord. Sorry, my lord.
no, otherwise I'll recommend that your name should be deleted from the list of legal aid counsel. Have you understood
Yes,
the
ma'am.
implication?
My lord.
So better you file an application for conversion. Otherwise, I'll say that the
So time may be kindly granted for filing the application for conversion of the.
you make a on the request of Ms. V.R. Sultana and legal aid counsel is the case on so and so date. You make an application.
30.
Otherwise, a presumption will be drawn. Have you understood? That this counsel has gone by the words of the litigant, who himself has sought to avail legal aid. Read and come. We don't encourage.
Item 41. It was not 30 this is 30.
Must have like.
Yes, what is this?
My lord, there is delay of 1100.
Corally Johido, something, and what is, on which case? Sessions case.
Lordship. There are 4 applicants, Lordship.
4 applicants.
Yes, sir.
Okay.
Convicted by the learned additional CJM. Thereafter, we filed appeal before the session judge. The sentence was converted and modified, Lordship. Lordship, may kindly see the relevant portion. Relevant portion, page 15, last paragraph, Lordship. Considering the fact and then.
How much days delay?
A delay of 1154 days. Lordship, after this conversion, the petitioners were informed by the learned counsel, but they wrongly understood. They were under the impression that they were acquitted, Lordship.
Whatever, we have to issue notice at this.
Lordship.
Third, Mr.
M.I. Hussain, Lordship.
Law School Learned Counsel for the
M.I. Hussain.
M.I. Hussain, Learned Counsel for the applicants, and Mr. M.P. Goswami, Learned Additional Public Prosecutor for the opposite party, number 1, State of Assam. This application is filed seeking conversion delay of 1154 days, which period of delay has occurred in preferring the accompanying criminal revision petition against a judgment dated 12/7/2022, passed by the appellate court, confirming the conviction of the applicants, and thereby, reducing the sentence.
Lordship.
Post up. Issue notice returnable on so and so. The applicant shall take steps for, as Mr. Goswami, opposite party number 1, no formal notice. Steps upon 2 and 3, speed posts within 3 working days from today.
9-2.
Obliged.
Item 42.
And there is no reprehension on behalf of the petitioner today on call. Against what?
So regarding my lord, this is a limitation petition. Yes,
Criminal revision petition, huh? IA.
I,
IA criminal revision petition against what?
against
Okay.
the
Okay. Appeal.
judgment, yes, my lord.
There
Against
is no
criminal
petition on
appeal
behalf of the petition criminal call.
to Public 20.
Release the case again. For insult justice on January 2nd. 21, Mano Duke.
21.
Hmm.
Item number 43.
Yes, Mr. Gugwe.
Lordship, there is a IA for condonation of delay,
How much?
90 days.
Criminal appeal.
Criminal appeal, my lord. POXO section is there, so notice at this stage, my lord.
How much the sentence?
5 years under section 10 of POXO.
Hold on, 90 days.
Yes.
Because at the time of hearing the appeal will
Yes.
hear. So for condonation is between the applicant and the court.
Court, yes.
Yes.
It is a discretion of the court.
Yes.
So notice may be issued, my lord.
No, we are condoning it.
Yes. Yes.
On the first itself, you are notice.
Yes. I was impatient that POXO section is there, so.
পক্ষ আছে নহয় লিখা আছে যে নালাগে at the time of appeal আমি শুনিম on merits. Heard Mr. B.V. Gogoi Learned counsel for the appellant and Mr. Applicant. And Mr. M.P. Goswami Learned additional public prosecutor for the opposite party, number 1, State of Assam. Post of the instant interlocutory application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 68 days, which period delay has occurred in filing the accompanying criminal appeal under Section 415 Bharatiya Nagarik Suraksha Anita 2023 against the judgment dated 17/7/2025 and an order on sentence dated 29/7/2025 passed by the Court of
Special Judge.
Additional Session
Yes.
Judge cum Special Judge POXO Kamrup Metro Guwahati Special Court for short in Sessions within bracket Special Case number 230 of 2023. Full stop. I have gone through the statements and affirmance made in the instant interlocutory application, in the instant application, more particularly, paragraph 4 thereof. Full stop. Having gone through the same, through the statements and affirmance, this court is of the considered view that the applicant has been able to make out a case, has explained the period of delay of 68 days, showing sufficient cause. Post of. The court has also taken note of the fact that by the judgment and the order on sentence, the special court has convicted the applicant under section after putting on notice, after putting the informant on notice in order to hear the accompanying criminal appeal on merits. Full stop. In view of the above, the instant application seeking condonation of delay of 68 days in preparing the accompanying criminal
90
appeal.
days.
Allowed?
90 days.
90?
90.
90 days
90 days.
is allowed. First of the registry to register the accompanying criminal appeal and thereafter to release the appeal for admission.
That may be fixed, my lord, for admission.
No, that will. No.
Yes.